Let's talk about John Lennon and his estate. You've got a big estate, a will that cuts out an heir, a surviving wife who isn't the mom of that cutout heir. So while that isn't necessarily a guarantee that there'll be a court battle after the will maker passes away, that's a lot of the ingredients for a will battle. I'm an attorney who's handled more than 1,000 estate cases, and I've prepared thousands of wills and trusts for estate clients here in Texas. And I did a deep dive on John Lennon's estate and found it to be incredibly fascinating. You would think that wealthy people would use attorneys like me to prepare their wills and trusts for them, but in a lot of cases, you'd be wrong. Here I'll talk about John Lennon, how he passed away, his will, and the legal battles that ensued after John Lennon passed away. First, John Lennon died a little before my time. He died back on December 8th of 1980. In fact, he was murdered by a deranged fan. The murderer plotted out the murder for months before he ultimately ambushed Lennon in the archway at the entry to Lennon's New York residence. Prior to Lennon's murder, Lennon was obviously a member of the Beatles. In fact, most consider Lennon as the leader of the Beatles. As a performer, writer, or co-writer, Lennon had 25 #1 singles in the Billboard Hot 100 chart. And what some people don't remember is that after the Beatles, but before his death, John Lennon collaborated musically with his wife, Yoko Ono. In fact, in 1980, just before John Lennon passed away, John Lennon and Yoko Ono released their joint album together. Now, that joint collaborative album kind of came out to really negative reviews almost across the board, but after John Lennon was murdered, that album became a big commercial success. And Yoko Ono plays a big part in the story of John Lennon's estate battle. As an estate attorney, I can tell you that most often we see estate battles among the heirs of the person who passed away. Now, the heirs are the people who would inherit in the absence of a valid will or a valid trust. So it's usually the wife or the children of the person who passed away that would be the heirs of the deceased person. In this case, John Lennon had 3 heirs. He had his surviving wife, we just talked about a moment ago, Yoko Ono, and then he also had a child with Yoko named John Lennon, but he had an earlier child, Julian Lennon, who also went by Jude. Now, Julian was born to John Lennon's first wife, Cynthia. So when John Lennon passed away, he had a blended family. He had a blended family and a really large estate. And that's a recipe for an estate battle. That large estate was estimated to be valued at about 220 million pounds at the time that John Lennon was murdered. If you watch my other videos, we'll call cases like this the evil stepmom cases. That's not to say that Yoko Ono is actually evil. I'm sure she's delightful. The reason we call these evil stepmom cases is because when you have these surviving wives where the deceased person had at least one child from outside the marriage, that's just a recipe for disaster. The likelihood of an estate battle between the child from outside that marriage and the surviving wife is much, much larger than if it wasn't a blended family. So here we've got 2 of the ingredients to an estate battle. We have a really big estate and we have an evil stepmom. Let's dive in to that insane battle between Yoko Ono and Julian Lennon, the child that was born to the earlier marriage. As I researched this case, I actually found the verbiage of John Lennon's will, which he created shortly before his death in 1979. There are a couple of things that are important to note here. First of all, John Lennon actually had a will, which is more than a lot of these celebrities can say. One thing that I note right off the bat is that it entirely cuts out Julian. Under this will, Julian gets nada. I also note that it put Yoko Ono in charge of the entire John Lennon estate. To the surprise of no one, Julian was not at all happy with his father's last will and testament. I'm sure he wasn't happy that Yoko Ono was in charge of that massive estate, and I'm sure he wasn't happy that the will gave him nothing. But while it's not surprising that there would be a legal battle in this situation, what is surprising is that battle lasts for 16 years after John Lennon passed away. Another interesting thing is that a lot of this estate battle was kept private. And a lot of times we see that these celebrity estate disputes are really public, which is sort of embarrassing for the family. But what we do know about the John Lennon case is that Julian alleges that Yoko Ono unduly influenced John Lennon to make that will. And what that means in the legal sense is that Yoko Ono put too much pressure on John Lennon to make that will. Now, it's okay to pressure someone to make a will. I'll pressure you to make one right now. If you don't have a will, you should get a will. Don't be like most of these celebrities that die without a will. Go get a will. Well, I guess I just pressured you to make a will, but I didn't do it too much. If I had pressured you too much, that would be legally considered undue influence. And that's what Julian said happened here. He says that Yoko Ono put undue influence on John Lennon when that will was made. And by the way, that is a common legal theory in a will contest case. A lot of times people will allege that this person would not have made that will but for the undue influence, the too much pressure that was put on them by somebody who stood to inherit. In the courtrooms, I've handled a lot of these estate battles. And whenever I see a child, an heir who's completely cut out of a will, one thing I'm sort of looking for is motive. Why would the person who made that will cut out that child? Because if I'm the judge or the jury, I might sort of look at some of the technicalities, like whether or not that was truly the signature or whether or not there might have been undue influence on the will maker. But at the end of the day, what wins or loses a lot of these cases is whether or not we see a motive for why the will maker would have wanted to cut out a child. So as I researched this case dealing with Julian, I see that there actually was a motive of John Lennon to cut out his firstborn child. For one, here's a quote directly from Julian. Julian says, "I've never really wanted to know the truth about how Dad was with me. There was some very negative stuff talked about me. Like when he said I'd come out of a whiskey bottle on a Saturday night, stuff like that. You know, where's the love in that? Paul McCartney and I used to hang out quite a bit, more than Dad and I did. We had a great friendship going, and there seems to be far more pictures of me and Paul playing guitar at that age than there are pictures of me and my dad." Along those same lines, Lennon himself said, "I don't love Julian any less as a child. He's still my son, whether he came from a bottle of whiskey or because they didn't have pills in those days." And further, Julian says, quote, "You think, where's the love in that? I felt he was a hypocrite. Dad could talk about peace and love out loud to the world, but he could never show it to the people who supposedly meant the most to him, his wife and his son. How can you talk about peace and love and have a family in bits and pieces?" So from the press and from those quotes, you can see that John Lennon and Julian were not necessarily close in terms of their relationship. So that kind of gives some motive in my mind for John to cut out Julian from his will. But there's another thing that I think gives John Lennon some motive. And this is the type of motive that we actually see really frequently. And that is that John Lennon had actually established a trust prior to the will to benefit Julian. So the motive would be, I don't need to give Julian an inheritance under my will. There's already money coming to Julian in the way of that trust fund. So he might think, look, Julian's already provided for financially there. And also, I think that the trust that was for the benefit of Julian might have been the product of the divorce between John Lennon and his first wife, Cynthia. So there could be some bitterness about the money that John may have been forced to provide for Julian. So maybe because he was forced, he's not really in the mood to give more assets to Julian. I know you're wondering, how did that 16-year court battle end up? Well, like in so many of these cases, it ended in a confidential settlement agreement. Now, as I researched the press clippings from that time, it seems to me that Julian walked away with a cool 20 to 25 million pounds from his father's estate as part of that settlement. Not bad. On the other hand, it's also reported that the John Lennon estate grew from about 200 to 220 million pounds at the time of his death to about 800 million pounds at the time of that settlement. So when you compare that 800 million pounds to the 20 or 25 that he got, you go, well, maybe that wasn't such a great deal. Keep in mind that if the will had been found to be invalid by the court, well, then in that case, Yoko Ono, the surviving wife, would have gotten half, and then Julian would have gotten 25%, and his brother Sean would have gotten 25%. So had Sean and Julian gotten a full share instead of this settlement amount, that would have been worth quite a bit more. And by the way, did you notice that the estate went up so much from 220 to 800 million, it's estimated? Well, keep in mind, Yoko Ono was the executor. She must have done a pretty good job managing the estate as the executor to grow it so much. When I researched that, a big part of that growth came from the sale of John Lennon's music catalog. And do you know who bought the music catalog? None other than Michael Jackson. He bought it for $47.5 million. And it's interesting, Paul McCartney tried to buy the music catalog, but he couldn't afford to outbid Michael Jackson. So Michael Jackson ended up with the music catalog. So there you have it. I told you about John Lennon, how he passed away, the 16-year estate battle that ensued, and how that estate battle got resolved. Pretty interesting stuff. What makes this case especially unique is that it's John Lennon, and that it was a 16-year battle, and that the estate was worth hundreds of millions of dollars. But having said that, there are a lot of things that are actually really common that as a lawyer I see almost every day. I mean, we see blended families, we see people who passed away without a valid last will or testament, and we see people that as a result of those problems end up battling it out in court. And while this blended family evil stepmom thing is not always going to end up in a estate battle, this particular case has a lot of the ingredients for an estate battle, the kind of ingredients that as an attorney I see all the time. I mean, here we have a blended family. The mom was not the mom to one of the children of the deceased. You're dealing with a large estate, which means there's sort of enough of a monetary incentive for people to fight in court. And you have a will that completely cuts out an heir. And so while that's not necessarily a guarantee for an estate battle, sure is a lot of the ingredients in the recipe for an estate battle. But I will say, at least John Lennon had a will, and that's more than most Americans can say. So again, I need to pressure you just a little bit, not too much, but a little bit. Go get your will done.